back on the record at 12:49.
Okay, I'd like to mark this as Exhibit 8.
Thank you. Is there more than one?
Are there more copies?
Yes, there
Oh,
should
there
be
are.
behind.
Here we go.
Does anyone have a cell phone in their inner pocket?
No, I'm sorry, I have one, so let me. Is that better? Okay, so this is another email and attachment. The email is Bates number 714-6630. And my questions are going to relate to the attachment.
Okay.
Okay. So first, in terms of establishing the email chain, the very top email is an email from Karen Harper to you, Mr. Ratliff. It's 2/29/2008. Do you see that, sir?
I do.
Okay, and it attaches a letter from the DEA dated December 27, 2007. Do you have any recollection of receiving this letter?
In 2007. I don't recall this specific letter, but since it's attached and it appears to have come to me, I'm certain that I received it at some point.
Okay. Do you recall ever discussing this letter with anyone?
In the government, letters such as this are called boilerplate. They send them out every once in a while just to remind the registrants and it comes in the government also, they do the same thing, to remind people of the rules and regulations.
Okay. And so if you could read the portion of the letter towards the bottom that I'm going to highlight for ease of reference.
On the front page,
Yes, on the front page.
what you've highlighted.
Yeah,
Okay.
it starts
The
with the
size of an order alone, whether or not it deviates from a normal pattern, is enough to trigger the registrant's responsibility to report the order as suspicious.
And so you would agree that this is the DEA's interpretation of a requirement that registrants are required to follow with respect to the size of an order.
Objection.
Is that correct?
Yes.
Then turning to the back of the letter,
Okay.
the very top paragraph. Okay. Could you read that top paragraph? It's the first few sentences.
Registrants that rely on rigid formulas to define whether an order is suspicious may be failing to detect suspicious orders. For example, a system that identifies orders as suspicious only if the total amount of a controlled substance ordered during 1 month exceeds the amount ordered the previous month by a certain percentage or more is insufficient.
Do you agree with that statement, sir?
I agree that DEA is telling us that.
And substantively, though, do you agree that reliance on a rigid formula to define whether an order is suspicious may be failing to detect suspicious orders? Do you agree with that as a matter of substance, sir?
Not necessarily. The reason I say that is there were most all of the registrants that we dealt with, and Karen Harper dealt with them, used an algorithm to identify suspicious orders, in that they deviated from the norm. They sent that to DEA. There came a time that Pete Kleisel called me and said, that's no longer effective. We know you've been sending us those. Please cease and desist, don't do that. You know, look at your program and do something different. And that's what started the total reinforcement, or the looking at the program and trying to make it the model of the industry.
And I understand that DEA is telling you that in this letter, but in terms of the substance of their concern, do you agree, well, strike that. Would you agree that DEA's concern that reliance on rigid formulas to define whether an order is suspicious, maybe failing to detect suspicious orders, is a valid concern?
Objection.
I don't know that I agree with that.
So you think it would be fine to rely on a rigid formula?
At the time, we relied on a rigid formula because there were times we had more information than DEA. A particular registrant, DEA had pulled their registration. So another distributor came in and wanted to order additional product. We knew that. So to say just because it deviates, it's suspicious, isn't always the case.
Well, but isn't DEA saying something separate? They're saying that if you're using a rigid formula to define whether an order is suspicious without taking a broader view or looking at more data, you may be failing to detect suspicious orders. Isn't that what DEA is saying in the first couple of sentences?
Objection.
You're saying this system fails, placed by a pharmacy, if the pharmacy, see, we're still confusing the manufacturer from the distributor to the pharmacy. So what you did is you stopped short of reading the rest of the facts that talk about this system fails to identify orders placed by a pharmacy if the pharmacy placed unusually large orders from the beginning of its relationship with the distributor. And you're trying to say, oh, well, this refers to the manufacturer also. Well, it doesn't say that.
And so your interpretation of this letter then is that there is nothing wrong with a manufacturer relying on a rigid formula.
Again, I'm going to say not necessarily that I agree with that statement because I think it's too rigid. What I'm saying is this is with regard to a distributor in pharmacies, and you're trying to put that on everyone that's a registrant, and I just think that's far-reaching.
Well, but the first page of the letter says this letter is being sent to, this is at the very top, this letter is being sent to every entity in the United States registered with the Drug Enforcement Administration to manufacture or distribute controlled substances. So this is going to every registrant.
It
both
is.
Manufacturers and distributors.
Exactly.
And the statement above relating to rigid formulas, my question to you is, for a manufacturer like Mallinckrodt, is it okay for the manufacturer to rely on rigid formulas in light of this DEA letter?
Objection.
I don't know if I have an opinion about it.
You're a director of security, sir. You don't have any opinion as
No.
to whether or not rigid formulas are appropriate with respect to detecting
Yeah.
suspicious orders?
Rigid formulas were used by almost all manufacturing registrant for years. So were they always wrong? Is that what you're saying? They've always been wrong. What we're saying is we got a great deal of information from that. And from that, we were able to determine if it's suspicious. What we were telling DEA is this is a deviation by those rigid numbers from what they've ordered in the past. It was my belief that they would use that information in deciding who they would audit or not audit. So when they're coming out and telling us this, they're saying that now it's your responsibility to, don't just send us this anymore, because it's really not helping. So that's a time when we changed and did what DEA required. They're saying, don't send us rigid numbers anymore. But what I'm saying is, I don't agree with the fact that those were wrong.
Okay, but you would agree that as of the date of this letter, which is December 2007, it was no longer appropriate to rely on a rigid formula in light of DEA's letter.
Objection.
Is that correct?
Well, if we go back, see, you're only taking part of that paragraph, and I just have fault with that. It talks about pharmacies, so it's saying if the distributors, which is different than the manufacturers, if they use rigid numbers in doing this, they may be missing this. So it's not saying just because all registrants received it doesn't necessarily mean that they're talking to the manufacturers.
Okay, and my question to you then, sir, is as a manufacturer, when you read this letter and you read that paragraph, and is it okay if you are a manufacturer to rely on a rigid formula for identifying suspicious orders?
Objection.
I understand that distributors may be doing something different or they may be differently situated. But with respect to a manufacturer, is it okay for a manufacturer like Mallinckrodt to rely on a rigid formula to define whether an order is suspicious?
Objection.
I'll just restate what I said. We believed giving those numbers to DEA would allow them to audit if they thought, because they have additional information. They have information from other registrants. Maybe that distributor was buying from 5 different manufacturers. So we don't know that. We were providing those numbers to them in an effort to alert them that this is a little out of the ordinary. And to say that's just absolutely wrong is just not right.
Well, I'm not saying that's absolutely wrong, sir. I'm asking a slightly different question, which is going forward from 2007 onward. I'm sorry, going forward from December 2007 onward, was it acceptable to rely on a rigid formula? I'm not asking you about rigid formulas prior to December 2007. I'm saying after the date of this letter, would it be appropriate for a manufacturer to rely on a rigid formula in determining whether an order is suspicious?
Objection.
I received a telephone call from Pete Kleisel at some time, and I think it was after this, where he said, yeah, don't do that anymore. Don't send those. So at that point, I said, okay. And I called Karen in and I said, Pete said, don't send these monthly letters anymore. So at that point, DEA is saying to a manufacturer, yeah, we don't want you to do that anymore. So when we knew that, that's when our program started to change. We started to define knowing our customer's customer. We developed that form that gave all this information from those pharmacies so we could make better decisions. So we were trying to help DEA in every way. But to say, I'm basing that, if I would have read this at the time, I would have said, well, they're talking about pharmacies, not manufacturers.
So your interpretation of this letter, I understand that you had a phone conversation with Pete Kleisel, but your interpretation of this letter and this paragraph is that this applies to distributors, not manufacturers. Is that correct?
As I read it today, that's how I interpret it.
Okay.
But you have to remember, this is, it's only 10 years ago, over 10 years ago.
But you don't have any reason to believe, as you sit here today, that you would have had a different interpretation of this letter 10 years ago.
10 years ago, I thought we had a great program in place.
And what do
So-
you believe now, sir?
I think our program has improved.
So you can put that aside.
Okay.
Okay, so this is now Exhibit 9.
Thank you.
So this is an email chain from Karen Harper to you with the Bates number 268860. And the bottom email is an email from you, Mr. Ratliff, to a number of people, CCing Karen Harper.
Okay.
So can you review the bottom email, please?
Thank you. Okay.
Okay. So, sir, can you read the top paragraph of your email?
I can. Jim. I guess it's to Jim Roush. Pete Kleisel, DEA Diversion Group Supervisor, St. Louis, just called regarding several letters he has received from you detailing suspicious orders. He advised that he needs more information in that, if it is suspicious, why are we filling the order? I explained that we use a calculation based upon an amount previously ordered. He stated, if you think it is suspicious, don't fill it. I will go into more detail on Friday.
Okay, thank you. So that is an email that you sent to Jim Roush, Michael Feeney, and Kathy Stewart. Does this refresh your recollection as to what Jim Roush, the role Jim Roush was playing in the suspicious order monitoring program?
Yes. Jim and works with Feeney and these. They obviously are the ones that are gathering the information, I guess,
Okay.
upon what orders are being sent. You have to remember, he didn't work for me, so I don't have a specific knowledge of what he did.
I understand that.
Okay. But this is what I was speaking of before when Pete called me and said, don't do that anymore.
And what you were referring to is Pete called you and said, don't send him any more letters. Is that correct?
Yes.
And what were the letters that Jim was sending to Pete?
They were I can't tell you specifically, but they had to do with the orders. And I don't know what their calculations were. I don't know anything about that. I just know that they filled out letters and sent them based on an algorithm that had been developed and was being used.
Okay. And do you see this, the sentence that I'm highlighting? Could you repeat that, please?
Several letters he received from you detailing suspicious order. He advised that he needs more information. In that, if it is suspicious, why are we filling the order? Is that what you're asking?
Yes. So that email sentence suggests that the suspicious, that you were, well, strike that. That line suggests that you were sending out suspicious, or you were filling suspicious orders after notifying the DEA of those orders. Is that correct?
Objection.
No, it's not correct. What he's saying is, I need more information. So what we've used is that algorithm that we believed was helping them. So he's saying, don't do that anymore. But he's not saying, oh yeah, you're sending me this information and it's suspicious. We were providing the information to them to assist them. So to say that any of those were suspicious, we just know they didn't fit within the algorithm.
But he also says, he advised that he needs more information, that if it is suspicious, why are we filling the order? So doesn't that last phrase, if it is suspicious, why are we filling the order?
Well,
suggest that
the
you were
rest of that
filling suspicious
conversation with
orders?
Pete, sorry, I didn't mean to talk over you. Please repeat yourself.
Doesn't that phrase, if it is suspicious, why are we filling the order? Doesn't that suggest that you were filling suspicious orders, and he's asking you why?
Objection.
That's not what he said related to me. He's just saying, don't do that anymore. If it's the algorithm, if it doesn't fit, we don't have enough information based on what you're sending us, based on your algorithm. And I'll give you more information on Friday about what's going on. So
And so that phrase then is inaccurate?
I would say it's poorly worded on my part.
And when he says, he stated, if you think it is suspicious, don't fill it. Why would he say that? Why would he say that to you? And you have that in quotes, sir. Why would he say that to you if he didn't have a concern that you were filling suspicious orders?
Objection.
I don't believe that Pete believed we were filling suspicious orders. If he had believed that, he and his team would have been at Mallinckrodt going through all of our records. He was just explaining to me in a very emphatic way to change what you're doing. And that came out of headquarters. And so, did he say that? Yes.
And what did he want you to do? Well, strike that. What were you doing that he had concerns about?
Objection.
We were using an algorithm as all the other registrants were. And he's saying don't use that.
And what did he want you to do instead then?
Providing more information.
So I want to make sure I understand what you mean by you say you were using an algorithm. So you were applying a formula to a group. Well, do you know if this algorithm was applied to all of the orders for your opioid products or only some?
Objection.
I don't know that. Jim Roush would be a better source for that. He's the one that filled out the letters based on the orders that they received.
So Jim is running an algorithm on some population of orders.
You're putting words, I don't know if he was running on all of the, I just don't know that.
Sure, but he was clearly running them at a minimum on some, correct?
At a minimum on some, but I would think it was, the algorithm affected all of the customers.
Okay. So I understand that you're not sure whether it was all of them or some of them, but I guess my point is regardless of whether it was all of the orders or some of the orders, he was running an algorithm on these orders. And that algorithm presumably identified various orders. Is that your understanding?
Objection.
Yes, if they were out of, if they were higher than they had been, if it had increased at a certain time, there's a method to all that. I don't profess to know what it is, but I know we were doing that. And he was being very specific about this, about us stopping with the algorithms.
Okay. So presumably after April of 2008, well, strike that. I take it you responded to his direction by stopping use of the algorithm. Is that correct?
I think that's what I did with this email.
Okay. And so what took its place? Instead of using an algorithm to identify suspicious orders, how did you identify them?
Well, you'd have to ask Karen Harper. We started a new program. I can't tell you the exact date that we started sending out those forms to identify all of the other information. I just don't know the answer to that.
And you reference in the second paragraph Frank Sapienza.
Yes.
Who is he?
He was with DEA.
And the reference is you have a call planned with Frank Sapienza on Friday to strengthen our suspicious order monitoring system. I'm sorry, our suspicious order identification system. Do you recall anything about that call with Frank?
I don't.
Do you have any recollection of how you were going to strengthen your suspicious order identification system?
Not at this point, I don't.
Who would have been in charge of that project?
Karen Harper.
Do you have any recollection of your involvement in that project as you sit here today?
I'm sure I assisted, but I can't tell you that. Karen is very informed and knows everything there is about DEA compliance. So she would have taken this on as a responsibility to write a program. Did I read it? Did I look at it? Did I make recommendations? At this point, I can't tell you. You know, would that be normal? Yes.
Okay, and when you say you will go into more detail on Friday, that's in the top paragraph, do you recall what any of those details were?
Can't remember the conversation.
So all you recall, right, all you recall based on this email today is that you received a call from Pete Kleisel, and as a result, you directed Jim to stop sending him letters, and Mallinckrodt stopped using the algorithm. Is that accurate?
Objection.
I think that's accurate.
Okay, so we're at 130. No, I'm sorry. Oh, I took it. Okay. Okay, I believe we're up to Exhibit 10.
Thank you.
So this is an email from Karen Harper to you,
Okay.
dated March 3rd, 2008. It's got Bates number 1308810. And the title of this email, is DEA Compliance Monthly Highlights, February 2008. Do you see that, sir?
I do.
Okay. Do you recall receiving, well, strike that. Were these emails that Karen sent out every month?
Objection.
Well, it says DEA Compliance Monthly Highlights, so there's an assumption to be made, but you have to remember this is over 10 years ago. So do I remember receiving this? I see my name on it, and that's about all I can tell you about that. Over 10 years.
And you're the only one that's receiving this email. So why is she sending this to you?
She may have worked for me at the time, I don't know.
Now, do you see the section marked suspicious order monitoring?
Uh-huh,
Okay.
I do.
And I guess the second line of that says, further, the need for comprehensive review and upgrade of our suspicious order monitoring program has received elevated priority. A conference call on the matter with corporate logistics is scheduled for tomorrow. Do you see that?
Nope, where is it?
Oh, let me highlight it for you. Let me try to.
Okay. So you're saying further, the need for a comprehensive review and upgrade of our suspicious order monitoring program has received elevated priority. A conference call on the matter with corporate logistics is scheduled for tomorrow. I see that.
Okay. Do you agree with this statement? Meaning in March of 2008, do you recall the need for a comprehensive review and upgrade of your suspicious order monitoring program? And do you recall it receiving elevated priority?
Objection.
We constantly tried to upgrade our program to be the best for any manufacturer. So when I read this, it does not surprise me that it's written in that way, and I think we were always striving to have a better program. So if that answers your question.
But this references a comprehensive review and upgrade, and it notes that that has received elevated priority.
I don't
So
know what
that would suggest something other than
Yeah.
sort of routine improvement, would it not?
I'll repeat, this has been way over 10 years, and for me to look at that and make a decision on what that meant or who did it or when they did it is really kind of, I just can't tell you that. I'm saying we were constantly trying to upgrade our program to be in compliance. So if we needed to have a better program or yeah, I think we could always say we can improve. So, but you're asking questions that are, we're going on 11 years here. So I've been retired 6.5. I mean, I know you want me to say certain things, but I just can't. So.
Well, sir, I don't want you to say anything. I'm just interested in what your recollection is, and that's why we're going through
well, that's
these
my
documents.
recollection. Thank you.
Okay. And do you have any recollection of what triggered this comprehensive review and upgrade?
Well, I don't know. So was it the 3 April 1st? No.
Okay. And with the reference to received elevated priority, do you know?
I have no idea. I have no idea in the world. I don't know who the elevated priority would have come from or anything about it.
Well, you indicated that Karen Harper at this time may have been working for you. Is that right?
Well, I said may have been working for me. So I don't remember. She worked for me for a time.
But you don't recall any particular urgency in early 2008 regarding the upgrade and review of your SOM program?
You can ask me this for 10 times. I'm going to tell you I don't recall this because of the length of time that's passed. I've been out of the company for 6.5 years. I'm doing my best to cooperate, but if I don't remember, I don't remember.
Well, and the purpose of these documents is to see if they can refresh your recollection.
Mm-hmm. And I'm saying they don't.
Do you recall any concerns that Mallinckrodt had in this time period, so early 2008, regarding its SOM program?
Objection.
We wanted to have the best program possible.
Well, I understand
We were
that,
constantly trying to upgrade the program and make it and obtain additional information so we could assist. There was a time we thought that our distributors were doing their due diligence. We reviewed, they sent us all of their programs in written form, and they look really nice. But unless you drill down beyond that, you don't really know if they're, doing what they should be doing, their due diligence. So that's when we started to develop the form that we're asking our salespeople to go out on all of our customers and give us this information so we can make the best decision possible. So we're ensuring that we're not sending out anything that's suspicious.
And my question to you is slightly different, which is, do you recall any concerns at this time period, which would be March of 2008?
I don't. Sorry.
Now, sir, you've repeatedly referenced that you were continuing to improve your program. What's the basis for that statement?
That's the form that we developed to ask questions about not only from the distributors, but from their customers. So we as a manufacturer sold to distributors. And in many conversations with DEA, we were looking at, okay, now we're going to have to go to the customer, our customer, the distributor, to their customers to determine if they're actually doing what the distributor should be doing in reviewing. So, yes, we were doing that. We were constantly trying to upgrade that to make sure we had enough information to make decisions like that.
And when did that occur?
I can't tell you, I don't know.
Other than knowing your customer's customer, what other steps did you take to improve and upgrade your program, which you said you were doing constantly?
I mean, that's knowing our customer's customer was the thrust of that program at the time.
So
Because-
that was the improvement, sir.
To the best of my knowledge.
And so when Karen is March of 2008 talking about improving the program, your recollection is the component, what she was, I'll strike that. Your recollection is that that improvement was knowing your customer's customer. Is that correct?
Objection.
I can't tell you at this time, sitting here, exactly when the form was developed or when we started doing that. I just can't tell you that. I have no memory of exactly when that happened.
Okay.
But I know that we started to do that. And the exact date, I just can't tell you. I don't know.
And what do you recall about the form? I mean, we've repeatedly discussed this form. What do you recall about the form? Who did it go to? What did it ask for? What type of information was it trying to seek?
Objection.
I mean, I'd love to see the form and I could explain it to you. Do you have the form?
We have, well, we've seen several forms. They appear to be drafts. So to be honest, I'm not sure.
I'm sorry. Yeah.
So as you sit here now, and we'll go through additional documents.
Okay.
But what is it you recall about this form?
That it stated the name, it stated the proportion of controlled substance to non-controlled substances, the number of cash customers as opposed to insurance customers or whatever. And I know it talked in terms of the two highest prescribing doctors. You have to remember, over 10 years old, I mean, that's just really a vague regulation. So I'm doing my best to help you.
So here we go. Thank you. So this is an email with several attachments. And why don't we start with the email? So if you could review that and let me know when you're ready.
Okay, I've read that.
Okay.
Excuse me.
So this is an email from Karen Harper to you, Michael Feeney, Jim Roush, Kathy Stewart, and Kimberly France.
Mm-hmm.
And it's dated April 10th, 2008. Its Bates number is 273902. Do you recall receiving this email?
My name is on it, so I must have received it, but I don't recall receiving it.
Okay. Now, in this, Karen is raising various questions regarding improvements to the suspicious order checklist. Is that accurate?
That's what it says.
Okay. And what do you recall about what the suspicious order checklist was?
I don't really recall it at all.
Okay. Well, so why don't we look at some of the attachments then? Because I believe one of them is a checklist. Well, actually,
Okay.
two of them are checklists.
Okay.
Okay. So the controlled substance order checklist, that's a first attachment. Do you see that?
I do.
And just so I understand how this checklist was used, this would be completed by the customer service representative. So this wasn't part of the effort to know your customer's customer, was it?
I think it was part of the overall, excuse me, suspicious order monitoring program. Did I ever see these? No. was I aware that there was a checklist probably at that time, but I think it was part and parcel to the suspicious order monitoring program. They were trying to bring everybody in on the same page.
The next attachment is a overview of something called the Integrity Chain Pilot Program. Do you see that?
I do see that.
Do you recall anything about the Integrity Chain Pilot Program?
No?
The very top paragraph, right underneath background, could you read that for me, please?
As a growing leader in the pain management category, Covidien has a social and business obligation to prevent abuse, diversion, and theft of its, whatever. Something wrong there. Detailed data through surveillance and pharmacovigilance is an important resource for the company.
Okay. So recognizing that there appears to be a word missing, other than that, would you generally agree with that statement?
I don't know what pharmacovigilance is.
Well, how about the sentence, as a growing leader in the pain management category, Covidien has a social and business obligation to prevent abuse, diversion, and theft of something?
Objection.
As a manufacturer, I don't know how we have an obligation to do that. I don't know what the Integrity Chain Pilot Program is or who wrote the document. And sometimes they use words and phrases that aren't necessarily in keeping with a manufacturer. So they're saying, whatever this program is, that we should be doing that. And we had people at some point that came in and tried to provide information that it was their project, their pet project. So am I saying that we were? No, I don't think so. I don't think that's the job of a manufacturer at all. Our job is to prevent diversion. But as a growing, that's somebody's special project. They decided that we should have this obligation. So do I agree with that? No.
Well, so what part of the obligation do you not agree with? Because it says Covidien, as a growing leader in the pain management category, Covidien has a social and business obligation to prevent abuse. Do you agree that there is an obligation to prevent abuse if you're a manufacturer?
Objection. We have an obligation to prevent diversion, but there's no way as a manufacturer we're going to be able to prevent abuse. If down the line, I'll give you an example, is in a prison. There's never a perfect system. You're always going to get drugs into a prison. Even the most hardened prisoners or prisons get contraband into that prison. So what you're saying is we have an obligation to prevent abuse. The doctor has an obligation. The pharmacist has an obligation. But the manufacturer, I don't believe so.
Okay, so the manufacturer, in your opinion, does not have any obligation to prevent abuse.
It's our responsibility to prevent diversion.
What's the difference between diversion and abuse?
Well, abuse would be someone going into a pharmacy with a script from a doctor who writes them for a certain amount of money and going out and either selling those drugs or taking them, and that's abuse. So is it our responsibility to prevent that? No. There's no way we could do that. So.
So what you described, sir, someone coming in with a script that they paid money to a doctor to obtain and having it filled, and then either taking the pills themselves or selling the pills, isn't that what occurs at a pill mill?
At what?
Objection.
Isn't that what occurs at a pill mill? Isn't that what happens with pill mills? People come in with scripts that are probably not legitimate. They obtain products, and then those opioid products make their way into the illicit market.
Objection.
Isn't that the problem with the pill mill, sir?
Yes.
Okay. And you do have an obligation. Your diversion obligation is to prevent your products from ending up in pill mills.
Objection.
Our obligation is to determine if our distributor has a program in place to do exactly that. So what we found out was they weren't fulfilling their obligation in every instance. So then we went further to go out and determine who those customers were to see if they were providing licit or illicit pills in the market. So the first responsibility is to the distributor. So we took it upon ourselves to go out and find out who those customers, our customers' customers are, to try to prevent that. So,
But if you determined that a customer's customer was a pill mill, then you had an obligation to cut them, to direct the distributor to cut them off, did you not?
Objection.
absolutely. Absolutely. And we did that many times.
And then, can you read the highlighted section in the paragraph underneath compliance needs, simultaneous abuse, and diversion monitoring, please?
Could you tell me who wrote this?
Well, sir, to be honest, it's not clear to me who did write this. This is,
Okay.
what I've got is the attachment to the email.
Okay, so we don't have any idea who wrote it. If it was a pet project that someone brought in at a time, you don't know that.
Well, procedurally speaking, there are limits to how many of your questions I can answer, but
Okay.
I'm comfortable saying I don't know who wrote this,
Thank you.
and hence why I'm asking you
I
about it.
appreciate it because I don't know who wrote it either. Okay, Covidien currently monitors diversion of our product through transactional data via electronic exchange and audit services from manufacturer to direct customer. Although these systems meet current standards for monitoring diversion, we are limited by our inability to track resources simultaneously through a comprehensive monitoring system that utilizes all sales and supply chain data. This is occurring at a time when prescription drug abuse, misuse, and diversion are increasing, which we anticipate will prompt the enactment of stricter monitoring requirements.
So focusing on that last sentence that you just read, this is
Okay.
occurring at a time when prescription drug abuse, misuse, and diversion are increasing, which we anticipate will prompt the enactment of stricter monitoring requirements. Is that an accurate statement in your opinion? And the
Yeah.
date of this email and presumably this attachment is going to be April of 2008.
So 10 and a half years ago. So I don't know that. And I don't know who wrote the document. I don't know what their ability to have this information would be. And I just don't know that I could say with any specificity that this is accurate. I just, I don't know.
Well, is it fair to say that over your time at Mallinckrodt, which spanned from 2000 to 2012, there was an increase in drug abuse, misuse, and diversion? Is that accurate?
Objection.
I think it's probably accurate.
And did that prompt the enactment of stricter monitoring requirements, sir?
Objection.
DEA never gave us any advice on what we should do or not do, other than not to send any more letters with the algorithm, okay? But they never said, you need to do this or that. At one point, they said it would be nice if you know your customer's customer. And that came, as I said, not directly, but it came through a sidebar from DEA. So did we do everything within our power to start identifying those customers? Yes. We were doing our very best to identify those people. But did the DEA ever say in writing until much later when we had the earthquake meeting at the end of 11 when they said you need to know your customer's customer? Before that, it'd been it'd be nice if you knew that, but they would never give us any instruction on what they meant.
Do you know if this pilot program was ever implemented, this Integric Chain pilot program?
I have no clue. I don't know who wrote it. I don't know. I just don't know. You would think there'd be something on here that would identify the writer.
Are you familiar with 852 sales data?
No, I don't know what that means.
What about 867 sales data?
Is there someplace I could look at this? I don't
No,
know what that means.
it's not going to be
Yeah.
present here. I'm just asking if you're
I'm not
familiar
familiar with
those
sales
terms.
data.
Now, after the Integra Chain overview, there is this new customer checklist.
Okay?
Now, do you recall that we were discussing a form, probably 10 minutes ago?
Objection.
Okay.
So is this the form that you were referencing with respect to the form to help you know your customer's customer?
It's familiar, so it very well could be that form.
And would you have been involved in developing this form?
I don't think so.
Do you recall ever reviewing this form when it was filled out?
Yes.
And what did you review it for? What was the purpose of your review?
We needed additional information on registrants to see if we felt that they were legitimate.
And can you walk me through how the information in this form would have helped you determine whether strike that.
Do you have where I can see the whole thing?
Yes,
It's cut off at the bottom and
it's in the back of towards the
that's
end of.
this?
Can we have the Bates number?
Yeah, it's Bates number 273907, so it should be as part of that document.
Thank you.
Sure.
Yeah, this isn't the form.
Yeah.
This is not the one I was talking about.
Understood. Do you recall ever reviewing this particular form, though, when it was filled out?
No.
Now, the next attachment, and it's Bates number 273908,
Okay.
it's a controlled substance suspicious order monitoring, and it's a DEA compliance procedure. This appears to be on a standardized form. Is that accurate?
Yes.
Okay. And the originator is Karen Harper. What is this form? What is its function?
Objection.
Let me put that another way. How did Mallinckrodt use these types of forms internally? Is this a formal policy document, or I'm trying to understand what I'm looking at?
Objection.
I know I've seen these and seen more than one of them. How it was implemented, I'd be guessing. So.
Now, on the back page, it has responsibilities, and then it identifies various departments. Do you see that?
Yes.
Okay. So you've got the customer data integrity group, performed Dun and Bradstreet information check on new control. Well, actually, strike that. Can you review this and let me know if you recall this process ever being implemented?
After all these years, I just can't remember it.
Okay.
I mean, I just can't remember.
Now, with respect to security director, that would have been you, is that
Yes.
correct? Do you recall if this was an accurate description of your role in 2008?
Objection.
Again, I can't recall. I just don't know. Thank you. Thank you.
So this is an email from Karen Harper to you. It's entitled DEA Compliance Monthly Report, May 2008, and it has a Bates number 2908468. And I only want to ask you about two things: the regulatory interpretations and the suspicious order. Well, it's the suspicious order mentoring. I suspect that may be a typo.
Okay, I've read the regulatory interpretations. What other?
Okay. The one up top saying suspicious order mentoring.
Okay.
Okay, so it says under suspicious order mentoring, and I think that means monitoring.
Okay.
The team continues work and 3 meetings were held in May. Is the reference to the team the SOM team?
Yeah, I don't know.
Okay. And I take it you don't recall anything about meetings being held in May on suspicious order monitoring or mentoring?
No.
Okay. Now, the next sentence references a procedure that is in draft 3 revision and a subcommittee which has become work on which algorithms will be used to screen orders of unusual quantity, frequency, and pattern. So,
Okay.
do you have any recollection of a subcommittee?
No.
Okay. Now, this is dated June of 2008, and it's referencing work on algorithms, which will be used to screen orders of unusual quantity, frequency, and pattern. So if you will recall, in April of 2008, you had a conversation with Pete Kleisel. Do you recall that?
Yes.
And the upshot of that conversation is that you were to stop, well, Jim Roush was to stop sending him letters and using that algorithm.
Objection.
He said, don't send us letters using the algorithms.
Okay.
It doesn't mean that the algorithms aren't effective, because that's what they're saying here, I think. That the algorithms have some benefit to us. So that's what I get from reading it. But do I recall it? No.
And so do you have any recollection of whether the algorithm was changed or modified over time?
I don't.
Okay. And actually, you don't recall whether the algorithm was still being used after April of 2008?
I don't. I know that they weren't sending letters to DEA with it.
Going to regulatory interpretations,
Okay.
it says, can you read that first sentence?
As newly appointed dosage customer service manager, Kathy Stewart requested several regulatory interpretation pertaining to DEA 222 overshipment and states versus federal controlled substance laws.
Do you know what that is in reference to?
No. Is it all from this?
That's all for that.
Thank you.
So the questions I have for you, sir, relate to the back page under ongoing projects, and in particular, it's the second bullet point.
The second bullet?
Yes, the one that I'll highlight it here. Do you see that highlighted section, sir?
I do.
Now, the first sentence references HDMA industry guidance. Do you know what is HDMA industry guidance?
No.
Okay. It also references a significant gap will be worked wherein HDMA suggests that the customer, as opposed to the shipper's sales rep, fills out the information gathering document regarding business background, customer base, state, and federal license, and signs and notarizes the statement. Do you see that sentence?
I do.
Do you know what that is in reference to?
I don't.
Okay. Do you recall ever becoming aware of a significant gap in the program?
No.
The second line from the bottom says, further, HDMA endorses an electronic order monitoring system and we need to determine status. Has pilot program been run? Well, do you know what HDMA is?
I don't.
Okay. And do you have any recollection of an electronic order monitoring system?
At this time, I don't. I just don't.
And the last sentence is, more work on suspicious order monitoring program will be on the agenda for January.
Okay.
So based on the documents, sir, it appears that Mallinckrodt was working on its suspicious order monitoring program since early 2008 until early 2009. Is that accurate?
We were constantly refining, reviewing, and improving the suspicious order monitoring program. So if that's what you're saying, yes.
But do you have any recollection of when the enhanced or new suspicious order monitoring program was implemented?
I believe it was always in a stage of, it was always being used as it was being reviewed and improved, is my recollection.
But you're not aware or familiar with any of the details of that SOM program as you sit here today?
Say that one more time, please.
You're not aware or familiar with any of the details of that SOM program as you sit here today?
Objection.
Was I aware of the suspicious order monitoring program? Is that what you're asking?
No, I'm asking about the specifics of its implementation. Do you know whether there was an algorithm in effect? Do you know when the customer checklist was rolled out?
Objection.
I take it you don't recall any of those details.
I don't.
Objection.
So your basis for saying that there was always some type of program in effect is what? Is it your general recollection, or
Yeah.
why are you saying
Karen
that?
would come in from time to time and say, we're going to do this. And I go, okay. She was right next, the office right next to me. And so did that mean, did I know at the time? Maybe. This is we're getting only 9 years ago. What I'm saying is, would I have known at the time what was going on? Yes. But what you're asking me is to review things that I haven't thought about in all those years. And today is the first time I'm looking at this in 9 years, 10 years, 11 years, and asking me to recall those details. And I apologize, I can't. My memory is not good enough to go back and look at this and say, yep, I just don't remember that.
So if I wanted to determine what the suspicious order monitoring program was in effect, say in July of 2008, where would I go? How would I do that?
I would talk to Karen Harper.
Okay. Is there any formal document that you're aware of that would tell me, this is a...
Did we have a specific date that said, okay, now the program's in place? I don't know. I don't think so. I think it was a gradual implementation, and I apologize for talking over you.
That's
Try
okay.
not to do that.
So if you got a new president of specialty generics and he wanted to know, he comes in August of 2008, and he wants to know what your SOM program is. I take it he would have gone to Karen Harper? Is that how he would have learned about it, or?
Sure.
Objection.
Sorry.
So
That's
there's,
exactly the case, and she would have made a presentation to him.
Okay.
She would have done a PowerPoint and the whole thing.
but there's, to the best of your knowledge, there is no archive that has, you know, this, on this date, this program was in effect.
I don't know that. I just don't know that there was a specific date, and we said, okay, now we're rolling it out today. And so there was nothing before or nothing. No, that didn't happen. It was a gradual. I mean, she worked on this all the time, trying to put it together, so. Thanks. Sorry.
So this is an email chain between you and Karen Harper, and
Okay.
its base number is 283602. And you note that at the top, there's a discussion of, you know, flooring installation, and I don't have any questions about that.
Thank you.
But I do have questions about the email below that and then the email below that. So
Okay.
if you could review that in the email on the back of the page, let me know when you're done.
Okay.
Okay, and so this email, the very bottom email, can you please read that? It's not very long.
I agree with David and Kyle Wright.
Oh, no, I'm sorry, I meant the one on the full email on 283603, so the back of the page.
Yesterday, I had a lengthy chat with Matt Harbaugh and David Silver. We spoke briefly about the suspicious order monitoring program and its importance. David made the comment that if a distributor was ordering oxycodone and hydrocodone, a good test of their legitimacy was to determine if they are buying hydromorphone. Interesting thought. Let's discuss.
So what is, can you explain what's being, well, strike that. Who is Matt Harbaugh and who is David Silver? Or who are?
David Silver was a VP. Matt Harbaugh, I remember the name, but I don't know
Okay.
what his position was.
And David Silver was a VP at Mallinckrodt?
Yes, he was at headquarters in Hazelwood.
And you're discussing, well, what are you discussing in this email?
David was a computer wizard, a savant almost. He just could do just about anything with facts and figures, and that's my memory of what he was doing with the company. So he made the comment that if a distributor was ordering oxycodone and hydrocodone, a good test of their legitimacy was to determine if they were buying hydromorphone. interesting thought. Let's discuss.
And why would that have been a good test of their legitimacy?
I have no clue. I know that sounds terrible, but I can't remember even in 2011 is what it says. So we're back to only 7 years ago. You know, if I were guessing, it's a pain medication.
Hydromorphone is a pain medication?
Yes,
Though all three of those are pain medications, aren't they?
correct.
Well, why don't
So there's not much else I could tell you.
we look at the email above that from Karen Harper to you?
Okay? Okay.
So based on this email, Karen agrees, or I guess endorses the idea of looking at drug combination purchase patterns.
Yes.
Why would looking at drug combination purchase patterns be helpful?
You know, to determine the legitimacy of the pharmacy, I mean, they're looking for other tools to use, and that's what I get from that.
Well, and how would looking at the drug combination purchase pattern help you determine the legitimacy of the pharmacy? Is it if they're only purchasing oxycodone, that's a red flag? Is that what this is about?
I don't know that.
And then your email above is, thanks, I believe David was thinking more in line of pain relievers that are not as addictive, as opposed to only ordering those that are. Do you have any recollection of what you meant by that statement?
No?
Do you recall at a time in the context of your know your customer's customer push that you started looking at drug combination purchase patterns?
Objection.
I don't remember that.
Would you agree, though, that if you found out that a pharmacy was only purchasing oxycodone from a distributor, that would be a cause of concern for you?
Objection.
I would say yes.
We're going a little over an hour, maybe 5-minute break.
Sure, that's
Are you-
fine.
I mean,
Well,
I don't have a
Yeah,
problem.
actually, I'd like to take a break.
okay.
Okay.
Fine.
Good seeing you.
We're going off the record